Welcome back to For the Defense. My name is David Oscar Markus, and this week we have 11th Circuit Judge Andrew Brasher on the show. I met Judge Brasher at the recent 11th Circuit conference in Alabama, and he graciously agreed to appear on the podcast. He became an 11th Circuit judge at only the age of 39. And you might be wondering, what has this podcast become? Now we have all Alabama folks on, Judge Pryor, Judge Newsom. Last week was Caitlin Collins, and now Andrew Brasher, who's also from Alabama and was the Solicitor General there. You're going to hear he has many similarities with those Alabama judges, Judge Pryor and Judge Newsom, but also he's very different and he's his own guy. You'll hear about those differences, some in-depth discussion about recent criminal law cases he's decided, his philosophy on legal writing, and how he hires his law clerks, to much, much more. I hope you enjoy this next episode of For the Defense with Judge Andrew Brasher. This morning, I'm really excited to have Judge Andrew Brasher on the podcast. Judge Brasher, welcome. I'm looking forward to speaking with you this morning.
Thanks for having me. I like to do podcasts that I listen to. So I listen to your podcast, and I think it's a great podcast. So thanks for doing it. I know you've got a lot of other stuff going on, but I think stuff like this. One thing that I felt like when I became a judge on the 11th Circuit is that there wasn't the sort of collegial bar that I was used to for the short period of time that I was a district court judge. And I think, doing a podcast like this really sort of creates that kind of feeling, even though we are so spread out. So I appreciate you doing it.
It's actually one of the things I wanted to talk to you about. And just before we get into it, to introduce you, you went to Samford and then Harvard Law School, obviously clerked for Chief Judge Pryor, not the chief then. Worked in the Alabama SG's office. And it's interesting because there's been a bunch of others who have gone to Samford, Harvard, Alabama SG. You've argued in the Supreme Court. And what you were just talking about, you sat on the district court in Alabama before coming to the 11th Circuit. And one of the first questions I wanted to ask you, and you beat me to it, is how different it is being a district court judge and an 11th Circuit judge.
Yeah, so they are just radically different jobs, in my view, at least. I mean, I was only able to do the district court job for a year, which is probably not long enough period of time to claim to be an expert on it. But the thing that there are a couple of things that are different about it. One is I think the chief job of a district judge is to manage his or her docket and move the cases to a conclusion. Oftentimes, when you're the district judge, you're not actually making sort of the dispositive decision in the case. I mean, you're moving the case along, the parties are going to settle, or you're going to go to a jury trial and the jury's going to make the decision. And so it's just kind of a different beast than when you're on the Court of Appeals, where your job kind of day in and out is to make the dispositive decision in the case, right? I mean, we don't really do a lot of case management on the appellate level. The other thing I guess I would say is that when you are, which I sort of mentioned at the beginning, when you are a district judge, and I'm sure it's the same way where you are in Miami, you see the same lawyers day in, day out. Right. You get to interface with them on a regular basis, informally. So there really is sort of a local bar around the courthouse, and you're kind of part of that. One sort of odd thing I think to be on the Court of Appeals is you lose a lot of that. I don't get to see lawyers except for the rare oral arguments that we have. And it's rare that we see the same lawyer twice in a year, or at least for me, that I see the same lawyer twice in a year. So different than when you're a district judge and you're talking to, sometimes, I would spend 12 hours a day with a lawyer, like during trial, right? And so by the time the 2-week trial is over with, you've got a really good connection with them. So that's one thing I miss about not being on the district court, is that kind of like collegial aspect of the local bar.
Judge Moreno down here in Miami, he was the chief judge down here, and he loves having these huge calendar calls where he brings in all the lawyers, and he was up for the 11th Circuit many years ago. And we would tell him, "You're not going to like it up there, man. You enjoy it too much, having all the lawyers in your chambers, in your courtroom."
No, that's exactly. It's definitely. I mean, you get a lot less people interaction just as a general matter when you're on the Court of Appeals too.
Judge, you were appointed in your 30s to the district judge, and you moved up to the 11th in your 30s as well, right?
Yes.
I mean, that's really, really young. How was that being such a young guy on the court? I mean, I'm an old dude now, so I can't even imagine being on the court in my 30s.
Yeah. A couple of thoughts about that. One is I felt like that was actually a pretty good age to be on the district court, because like we were talking about, that's a very active job. I mean, I was in a place where I could get to work at 6 a.m. and work all day and
Right.
read stuff at night. I wasn't tired. I mean, I felt like I was energetic, right? I think that was helpful when I first got there, to sort of have a little bit of youthful energy. You could talk to some of the lawyers in my cases and find out whether that was true or not. But I felt like I was adding, there was a value add to have that kind of approach to the job. One thing about the judge job just in general is that you have such a group of people around you that have the experience that you don't have when you first start. I mean, it's unlike anything else, where, when you start practicing law, it's very rare that you end up practicing with someone who's been doing it for 45 years, for example, right? You might end up practicing with someone who's been doing it for 10 or 15.
Right.
But when you become a judge, especially a federal judge, your colleagues and your peers have often been doing it for 30 years. And so when I first got on the bench, I leaned a lot on the sort of older, wiser judges who had been doing this for a long time to learn from them. And I still do that. I've stopped doing that.
You and I were just at the 11th Circuit conference together in Alabama, and I saw Judge Choflat there. I mean, to see him, he's the guy has seen everything.
Oh, absolutely. No. And sometimes people ask me, what is the unexpected best thing about being on the 11th Circuit? And I always tell them it's the opportunity to hang out with Judge Joe Flatt, because the stories that he can tell you from, the 1980s, the 1970s. I mean, when he joined the district court, he had desegregation cases that he handled. And so the amount of institutional knowledge that he has just really is amazing. He really is. I mean, he's a national treasure. I remember reading an article about his legacy as a judge once. And, it was about how he had been chief judge in the 11th Circuit and handled all these significant cases. And then I flipped to the date and it was written in 1999.
Right.
So he has done so much even since then. But yeah, that's a great example of someone that, you can rely on for advice and guidance as you kind of go through this.
So Judge, this Samford, Harvard, Alabama sort of line here, it's pretty incredible, huh?
Yeah. So, I mean, so you mentioned, so Judge Newsom, Kevin Newsom was the first, I think, to go to Samford, to Harvard Law School, and then to become the Solicitor General of Alabama, and then, of course, to go on the 11th Circuit. And I've talked about this before. When I was in law school, I met Kevin at an event and really got sold on the idea that I needed to try to follow his career path. And a lot of the decisions that I've made kind of over my career have been trying to emulate Kevin Newsom.
Well, let me ask you about that, because Newsom, we had him on the podcast. I love the guy, but he just came out saying, we should be using AI in opinions, and wrote that in an opinion. What do you think about AI and opinions?
I will say, at this point, I think I've stopped trying to emulate Kevin Newsom because it's impossible, right? I mean, he's got his own style and his own kind of thing that he's doing. On the AI issue, I think he raises some really interesting points. My main concern, I guess, which I think he discusses in that opinion you're mentioning, or at least hints at, is that I just don't think that large language models are at the point where we can really rely on them for the purposes that you might need to if you were a judge. I mean, one example is that they're not replicable. So, you could ask a large language model, explain this to me today at 10:30, and then I could ask it the same question tomorrow at 10:30, and it could give us different answers. And so you can't really use it in any systematic way, I think, at this point. Now, will it become where you can use it? Maybe so. But I feel like one of the real hallmarks of the judiciary is that we explain our decisions in a way that people can criticize. And they can look at our reasoning and say this doesn't make sense, and they can pick it apart. They can look at the sources we're citing and say that we're misunderstanding them or whatever. And part of the problem, I think, currently with AI is that you can't really do that if it's not replicable. Then
Right.
the public can't go and do the same query and then tell us that we did it wrong. So that's my main concern right now.
You know what I really like about it, and what I use it for is I'll use it to give me like the main cases on a particular topic and to summarize them for me. And it will do it in 5 seconds, where if I gave it to a first year associate, it might take a day.
Right.
So that I really like it because it just plugs me into the main cases on something, which is pretty good actually.
Oh, I think that's exactly right. And I mean, I don't really use it right now, but I have a lot of friends that use it for purposes of writing letters and things like that they would otherwise have to sit down and write from scratch. And I've talked to judges about using it for exactly what you're talking about, just to kind of generate case cites or law review articles that they can look at, which sounds like a great use for it. And I think that's, to a certain extent, I think Westlaw has that kind of use for it right now.
Right. And so, we have the Sanford, Harvard, Alabama SG, but we also have the Judge Pryor coaching tree. I look at it like the Belichick coaching tree, and it's the judging tree. I mean, it's really quite neat what he's done.
Yeah, he really, and what's so neat. So I was one of his first law clerks. I mean, I think I was his third year, which is just really shocking to me to think about, because I'm in my, I guess, fourth year now on the circuit. And man, when I was a clerk for Judge Pryor, he seemed to have everything understood and know exactly what he was doing, at least from the perspective of a 25-year-old at the time. And now to sort of be in the same position, I think, wow, do I have the same understanding of this job that he did when I was clerking for him? But he's just such a dynamic individual and has always wanted, I think, to leave the kind of legacy that he has created for himself, which is he's brought in great people, he's trained them up, he's invested in their careers, and it really is, sort of bearing fruit when you can look across the judiciary and see so many people that have kind of touched him in one respect or another. I mean, if you look at just the states in our circuit, I mean, you have district judges and Court of Appeals judges in Alabama that clerked for him. There's a judge on the Georgia Supreme Court that clerked for him. There's a district judge in Florida that clerked for him. And so he really is, he really is the root of a lot of people's judicial careers.
I've talked about this on the podcast before, but I only knew him, of course, from appearing before him, and we disagreed on just about everything. But because of this podcast and some other things, we've become good friends. And I love when he's down in Miami and we have lunch at Versailles and can just talk. I've come to love the guy, even though literally I disagree with him, I think, about 95% of topics.
Well, that's actually some of the best conversations that you will have with Judge Pryor is when you disagree with him, because he loves a debate. He loves to talk about stuff like that. So.
Yeah, no, he's great. And I know you've just written about becoming first, clerking for him and then becoming his colleague, and something you say you're asked about a lot. How is it being his colleague now from becoming his clerk?
Yeah, so recently the Alabama Law Review did a tribute to Judge Pryor, where they asked a lot of his former clerks and lawyers and people like that to submit these essays about him, and I was really happy to be a part of that. And the kind of theme of my essay was, what is it like being a judge on the same court as the judge that you clerked for? And to me, I think the short answer to that is that it's a lot like being a law clerk. You have the same kinds of conversations that you have when you were a law clerk. One of the odd things I think about the law clerk-judge relationship is that you work so closely together on cases for a year, and then the law clerk moves on, and you actually can't even talk about your cases with that person anymore. Not only are you not working together, but you can't even talk about the stuff that you're working on. And so to me, the real kind of eye-opening and really, I don't know, I was just really grateful for it when I joined the court, is the opportunity to just work with my old judge on the same cases again and have the same kinds of conversations we had when I was clerking for him.
It's really, really terrific. And I do note that you have disagreed with him before on the court, and in a pretty big case, an en banc case called Garcon, in which there was a discussion about how to interpret a certain part of the sentencing guidelines, and Judge Pryor wrote the majority opinion. You joined a dissent and also filed your own dissenting opinion, where the disagreement was about how to interpret the word "and." And so I guess a couple of things. One, you were vindicated in that by the Supreme Court. So I hope you've rubbed it into Pryor.
He knows, and I know that he knows, and that's
so there's that. And I guess my question is, when you guys were debating it and writing opinions, I mean, it must feel weird to now write your own opinion disagreeing with him. When you clerked, he obviously did. You couldn't write your own.
Yeah, no, and that's a great example of where it is just, on the one hand, it's very similar. I mean, we had so many conversations about that case, as you can imagine, right? I mean, where I was going to his office and we were talking back and forth, and he was trying to convince me to join his majority, and I was suggesting I just don't think that's right. And the one big difference, of course, is at the end of the day, I had my own vote I had to cast and had to figure out,
Right.
what I had to do. And so I did dissent from that en banc opinion, and that we've sat on a couple of panels together, and that dynamic has happened a couple of times where really when you approach an issue in a different sort of from different perspectives, just like when you're got a judge law clerk relationship, at least with Judge Pryor, you debate it for really as long as you possibly can debate it until one person convinces the other. The one difference now, like I say, is I have my own vote and I eventually have to make my own decision.
I will say you won't be surprised to know this, Judge. I agreed with Judge Pryor on that one.
Sure.
But what I love about that case and the Supreme Court case is the crazy lineups you saw, both in the 11th Circuit and in the Supreme Court. I was quite surprised, with Gorsuch's dissent, and that Justice Jackson didn't join it.
Well, I think Justice Kagan wrote the majority. I thought Justice Jackson did join Justice Gorsuch's dissent, but oh,
right, that's right. Kagan wrote I'm talking about Kagan. I got confused.
Yeah. So I don't know, that was an interesting issue. I thought if you look at the circuit split that developed on that issue too, it was really all over the place with the way people interpreted that statute. I think there are a lot of different ways to understand the Supreme Court's decision in that case. One way to understand it, I think, and maybe the way that, I don't know how Justice Kagan would sort of view her majority opinion, but I think that at least in the Fifth Circuit, for example, if you look at the Fifth Circuit's opinions on that issue, the split was sort of between a literalist approach to the statute, where, like you say, the question is sort of what does "and" mean, and a contextual approach to the statute, where you're looking beyond sort of what that one word is and look more in the context of the statute. And I think if you read Justice Kagan's opinion, that's really where she focuses her interpretation, is the context surrounding the word and not exactly what the word "and" means. That I think is somewhat the way I kind of understood the way the case broke down.
Fascinating stuff. I've heard, Judge, that you have a paperless office, which I mean, people can't see the back of my desk, but there's paper everywhere and I'm a mess. How do you do it? Do you read all the briefs online, or do you have them printed out?
So I don't print anything out. The only printing I do is if I'm working on an opinion, and sometimes it's better to print it out and read it in paper. If you've got, oftentimes it's better to read stuff out loud to yourself too, if you really want to make it good. So I've got a lot of different ways that I do sort of my office paperless. I don't want to be an ad for any particular program, but one thing that I've been using since I was a district court judge is a program called OneNote, which allows you to transfer things really seamlessly between an iPad, a computer, and then other people's computers that work with you. And so right now, all my briefs, all memos that are written to me, all the motions that are filed that I have to review, basically anything that I need to read or review, is uploaded to OneNote, and then that goes automatically to an iPad that I can look at, and it goes automatically to my laptop and my desktop. So I never have to print anything off.
And when you go to oral argument, you just bring that iPad and have all the briefs and memos on there?
That's exactly right. And the record, right? So it's also, I mean, one thing that when I was an advocate and I argued cases, I never brought the record with me, right? I mean, I don't know whether you do that or not.
I don't.
At the end of the day, there's so little that you can look at, really, and so little that it makes worth kind of bringing the paper. But when I go to argument as a judge, it's often really helpful to have the record there, not only just like during oral argument to check things, but also when you're preparing for OA, you can kind of look back and say, oh yeah, they're citing this document. I like to actually look at that. So good to have it there. And then in conference too, to be able to look at. And so one nice thing about having everything electronic is I get to have literally every document in the case without
a box.
Yeah, without a huge box, without dragging around into boxes. Exactly.
Do you miss arguing in courts? Miss being an advocate?
Yes. Yeah, a lot.
Yeah.
I miss being an advocate a lot. When my take on the practice of law was that you did all the other stuff to get to court, and the court part was the fun part.
I'm with you, man.
You're with me?
Yeah.
And so I miss the sort of going into court as an advocate. I enjoy going into court as a judge. I mean, I think there's an aspect of that that's also kind of fun. But being the one asking the questions and kind of poking at the issues and thinking about it that way is very different than being the one who is trying to persuade. And there is something that's just really special and interesting about being the guy in sort of the middle of the courtroom with the lectern, trying to convince people that you're right.
And how important is oral advocacy in the 11th Circuit? Like, has it made a difference for you in a particular case?
I've gone back and forth on sort of my answer to that question and what I think about it. One, I do think it's important. I think it's important in every case for the same reasons frankly, when I was a lawyer, that I thought it was important, because you can always lose your case at oral argument.
That's right.
Sometimes you can't win your case at oral argument. That is, you can't convince people that you're right if they kind of came in with the predisposition that you were wrong. But you can always say something in oral argument that ends up convincing someone that you're wrong, even though they thought right. So that's the first thing I would say. It's always there's always the option for that. As far as whether it's made up kind of change my mind, I will say there are some cases where I go into oral argument and look, it just is what it is, right? The case is what it is. It's highly unlikely anything in oral argument is going to change my mind. But there are lots of cases where I go into oral argument and I'm just kind of up in the air. I mean, I really am. And those are the cases where I feel like being able to talk it through and having the lawyers come in and being able to talk through the issues that I have, and also hearing the kind of the questions and the answers to issues that my colleagues raise, like that was really helpful for me. So I can't really, I mean, there are a couple of cases, I guess, that I could point to and say, well, this was a case where I went in thinking this way pretty strongly and then I got flipped. But most of the time when oral argument has an impact, it's because I'm kind of going in trying to figure out the right answer, and oral argument kind of helps me do that.
Do you think we have enough oral arguments in the 11th Circuit? I know the numbers are interesting. Like some courts give oral argument in a lot more cases than our court does. Do we have the right balance here?
We are really efficient in the way that we resolve cases without oral argument. We have a really high caseload. We still have the highest caseload per active judge of any circuit. So we can sort of have to be efficient in the way that we resolve cases. I would say personally, I haven't seen a case that I wished had gone to oral argument but hadn't. Mm-hmm. And I really haven't seen too many cases of oral argument where I thought like, I wish we weren't doing this. I wish we had just resolved this on the brief. So I guess from my perspective, I do feel like it's about right. I know that when I was a lawyer, I felt like all of my cases should be orally argued.
That's how I feel too.
Yeah, exactly. Yeah, exactly. Well, actually, this is what I thought. I thought if I was the appellant, then of course they should be orally argued because I need to win and explain why the district court was wrong. But I thought if I was the appellee, there should be no oral argument at all because I'm so obviously right. Like you should just.
Yeah, I'm almost never the appellee though on the criminal defense side. So I'm always asking for oral argument in every case.
Yeah.
What about advice for oral advocates? What should folks be doing differently than they're doing?
I feel like we have a really high level of advocacy in the circuit for the most part. I mean, I really do. The one piece of advice that I've always given is I think the right way to approach oral argument is the same way you would approach like teaching a class, that you're showing up to the argument with the idea that I'm going to, this class is called Why I'm Right.
I like that.
Appeal, right? And the point is to teach these people why I'm supposed to win this appeal. And so if you approach it that way, I just feel like a lot of other things kind of click into place. For example, when people are asking you difficult questions, that's great. If you were a professor, you'd want your students to poke at you and ask difficult questions so that you could respond to those, right? When you're talking and people aren't paying attention to you, then maybe it's time to change topics or do something else, right? Like, so a lot of the problems that people kind of like walk into at oral argument, I feel like it's because they aren't approaching it as they're trying to instruct and teach about why they're right, and they're more approaching it like a jury argument or something, and you're trying to like motivate or persuade, when really it's such an academic exercise. It's really more about instructing and teaching the panel why you're right.
I think we should title this episode "Why I'm Right." I think that would be a good title. So there's been, this debate sort of bubbling up, not just in our court in the 11th Circuit, but in courts around the country about sort of how opinions should be written. Should they have this informal writing? Should there be pop culture references? Should we be very formal? Your opinions are pretty formal. Is that where you fall sort of on this line?
Yeah, I think so. And I think a lot of that too can be answered by what do you view as the purpose of your opinion? So much of advocacy and writing and things of that nature that we do as lawyers is driven by who our audience is and the point of what we're doing, right? So I think folks who use a more sort of colloquial style and have like pop culture references and stuff like that, I think they just view their audience and the point of a judicial opinion a little bit differently than me. I mean, I view the point of a judicial opinion as basically serving on the circuit as serving sort of three functions. One, you're explaining to the parties the result in their case and why that result happened, right? Like I said before, the great thing about the judiciary is we explain why someone wins or loses, right? And so that's an important point. Two, you're explaining to the public and to the bar and other lawyers, what the reasoning was, not so much because they care about the case that you're resolving, but because they might care about the next case, or they might want to cite your precedent, or they need to understand the thinking of the judges for their own cases. And then the third audience, I view at least, is district judges and their law clerks. Right. I want my opinions to be where a district judge or a law clerk can say, look, we've got this issue. I want to know how it should be resolved. And the law clerk can look at an 11th Circuit opinion and say, this is what the 11th Circuit said, and this is why. And then that gets easy to apply to what they're doing. And so
I think we saw that in Garcon, where you were telling, district judges, hey, don't worry about this craziness. You can still sentence people the way you want to sentence people.
Yeah. And honestly, one of the happy feedback I got from that was I found that the probation offices were actually including that in pre-sentencing reports to just say, like, look, even though the 11th Circuit has said that there's eligibility for this, you don't have to do it if you don't want to. And so I thought, well, that was helpful, right? To sort of helping, I guess, others in the judiciary kind of do their jobs by the way you write your opinion. So I think like that's the way I view the point of a judicial opinion. And so I guess that's kind of how I'm writing them, is for that kind of those objectives in mind.
You spoke about camaraderie earlier, and I get it. The district court, there's just more people around, and there's a little bit more action. But I have to say, when I was at the conference with you all, that was my first time at the 11th Circuit conference. I was impressed by the camaraderie with the judges on your court, and it seems like you all are all very close, even though obviously there's differences in opinions on things. You all seem pretty close.
Oh, I think so. I mean, I feel like, personally, I think we've got a really great court. That is one of the things, like joining any institution or going to any new job, you're kind of worried about who your coworkers are going to be and who the other people that are already there and whatnot. But I would say the 11th Circuit is just such a collegial place. I mean, it really is. And it's one of the things, and I think, there are a lot of explanations for that. We're only 12 active judges.
Right.
I think that helps. We're all from the South. I think that helps. But also we make a point of doing things together, when we're sitting together, when we've got on box and things like that, to just kind of get to know each other as people. And so it's really is a very collegial place. That's one aspect of the circuit that I've really enjoyed.
Judge, down in South Florida, we don't really consider ourselves from the South.
Right. What's the old saw about Florida? The farther south you go, the farther north you are. Something.
That's right. Exactly right. I mean, it is funny as you go up north in Florida. I tried a case in Tallahassee. It felt like the South.
Mm-hmm. Yeah. Well, look, I would include the Cuban culture of South Florida as being a collegial culture as well. I mean,
absolutely.
No doubt about that, right?
Absolutely. So let's talk some substance on criminal justice issues, which I find the most interesting. And of course, this is mostly a defense podcast, although we've had so many judges on recently. I may have to change the name of it. But one of the issues that fascinates me the most is how technology and the Fourth Amendment interact. And you were involved in a really interesting case, McCall, about people's iClouds account and whether and how the police can get access to that. And in that case, the police got access to the whole iCloud account, and it seemed like the government was almost conceding that was too much, but rely on good faith. And we're seeing so much of that lately, Judge, where good faith sort of swallows the Fourth Amendment, and so folks on my end obviously get upset with that, but that's what happened in that case.
Yeah. So a couple of things about that I think are just really interesting about this area of the law. One, I completely agree with you. I think that the intersection between the Fourth Amendment and technology is really one of the most interesting things going on right now. But also, if you could look at any body of law and say how this body of law develops over the next 10 years is going to influence society and the country our children live in 50 years from now, it would be this area of law. Really important, I think, systemically for the way society operates. One problem, I think, one sort of interesting thing that your question raises about that, and we mentioned that in the opinion, is that, if you look, especially if you look in the facts of that case, this was the first time that that particular policeman had attempted to search an iCloud account. So I think at this point you can say, look, there's a lot of good faith deference that are going to go to the police because they're trying, we're creating so much information out there. It's stored in so many different areas and so many different formats. And just like anything else, it's going to be a while before everything sort of shakes out and you figure out, where the metes and bounds of the Fourth Amendment are in this area. I mean, I think as time goes by and more things get resolved, more issues like that get resolved, I think you'll probably see less good faith come up because you'll see less of a situation where the police officer is saying, look, my first time to do this search, the judge granted the search warrant, the company gave me the information. What was I supposed to do? Right. And one of the things that we said in that case, in part because of the issue that you raised, is the majority opinion says, look, if you're going to do one of these warrants in the future, you really should have a time-based limitation in what you're where you're authorized to get the information from. So if you're going to search someone's iCloud account or some other kind of I mean, I'm sure, we're talking, I'm sure a week from now, there'll be some other kinds of cloud-based storage that develops, but it's really hard to search those accounts for a specific file or a specific file type. But it's pretty reasonable to say, look, you can cut off the date of this search at a particular time and only have access to information around the particular date. So that's what we suggested that police officers do, in that opinion.
I don't think kids realize how much is stored on their cell phone, and that the world can see basically everything you do. It's pretty wild what phones have in that iCloud account.
Well, and it's wild too. So I mean, the Supreme Court has issued really, I guess, two cases on this, Carpenter and Riley, which I know that you're super familiar with. What's interesting to me is, in Carpenter, it was about location data that's basically being provided by your phone. But I suspect, I don't, have any evidence for this, but I suspect the kinds of things that the Supreme Court was talking about in Carpenter, we're so far beyond now what your phone is providing as far as information, right? The Supreme Court in Carpenter was talking about some location data that can be used. I just suspect, just looking at the dates of the cases, that now the location data is so much more substantial and so much more pervasive than it even was at that time. So I agree. I think it's certainly something that I don't pay attention to, right? How much data I'm generating about my life to these companies that can then, be accessed by law enforcement if they want to.
So Carpenter, the 11th Circuit predecessor to that was a case called Quartavius Davis. And I was familiar with it because I argued that en banc case in your court. It was before your time. But I thought, that was my opportunity to get to the Supreme Court. I had not been, and we lost in the 11th Circuit. And then, of course, Carpenter comes out the other way. And they did not take Davis. They took Carpenter the next terms. And it still eats me up that I didn't get to go up on that case because it was such a fascinating issue. And I've been trying to find a case to get up there on. And I took that case pro bono just because I thought it was such a great issue. And it was a lot of fun arguing in your court, that en banc issue.
Well, look, I'm jealous of you because I litigated in the 11th Circuit. I had several Supreme Court arguments. I never had an en banc argument in the 11th Circuit. So literally every time I walk into an en banc now as a judge, I just think to myself, I never had one of these as a lawyer.
It's really different and really difficult. I thought, if I had two in your court, and both times I have found it really, really hard because there's just so many folks. And I didn't realize that in the 11th Circuit, sort of one judge is assigned to each side before the en banc argument. I only found that out after the Davis case. So I thought that's an interesting way to do it.
Yeah. Well, I don't know. En banc is just its own unique animal from my perspective as a judge, because it's sort of like oral argument in general. When I was a lawyer, I wanted all of my cases to go en banc, and I wanted en banc arguments. And now that I'm a judge, I think, I don't know. Do we really hear this en banc?
Well, this is something I discussed with Chief Judge Pryor. When I first had him on the podcast, almost never would the court take a case en banc where the prosecution won. And now every time the court does take one of those, he sends me a note saying, "See, you were wrong about this." So he doesn't forget that I called him out on that. But I tell him I take credit now because I called out the issue, and so I take credit. So one of these issues about the Fourth Amendment and technology, and just the Fourth Amendment in general, that sort of drives me crazy, judges. When I was in law school, the court would take a bunch of Fourth Amendment cases every term. And those to me were always the most fun cases. You mentioned Riley and Carpenter. We don't see many Fourth Amendment Supreme Court cases anymore, which is so weird and disappointing to me.
Yeah, I agree with that. Obviously the Supreme Court can do what it wants to as far as taking cases. And they should just be clear, they should never take a case where I write on the Fourth Amendment. There's no reason for them to get involved in that at all. But if you look at Carpenter and if you look at Riley, both of those cases are trying to do is you have kind of long-term precedents. In Carpenter, it was about search as an incident to arrest. And in Riley, it's about the third-party doctrine. Right? I've got that right.
The other way.
Yeah, Carpenter's about third-party. Right. And Riley is about search incident to arrest. And they're trying to figure out how to apply those in sort of this, new world of technology, and they both cases kind of find a way to sort of minimize those exceptions that have been created or find that they didn't apply. And I just don't know if the court is interested in kind of entering this area again without sort of a view of how the Fourth Amendment and technology should work together that's more comprehensive, I think, than what we saw in those two cases. I mean, those two cases were just such one-off cases that they really don't create a body of law that can be applied in the future. And so I think the next Fourth Amendment case we get from the Supreme Court, this is just my prediction, will be one where the question is more sort of meta than those, and it'll be more about, should we do a rethink of the Fourth Amendment in light of the things that we're seeing, or should we continue to follow these kind of doctrines that developed when everything was physical searches and whatnot? And I'm kind of waiting for that case, but my guess is that case is the next Fourth Amendment case, and then after that, we'll get a flood of Fourth Amendment cases. So
I hope you're right.
That's my hope. So.
I hope you're right. It's really fascinating talking about rethinking issues. I mean, one thing that I can tell you're frustrated about with your opinions, and I don't know how anybody can't be frustrated, is how to deal with the criminal history, Armed Career Criminal Act, the categorical approach. You have an opinion in a case called Miles, where the defendant possessed a drug that he was using to manufacture, but it didn't count as manufacturing, and so was it a serious drug offense? And this whole idea of the categorical approach and criminal history, first of all, is impossibly complicated for practitioners and district judges. What should we be doing with this?
Well, I'll tell you. So, you mentioned practitioners. I mean, I've spoken to so many public defenders who've said, I can't advise my clients when I'm working on a guilty plea, when I'm figuring out what to do, about what their actual sentence is going to be, because I can't predict. Well, I mean, I guess they can predict, but it just takes so much work to predict whether they're going to be subject to ACCA or not, because it's got so complicated. My view of mandatory minimums in general is that I think the objective of a mandatory minimum, the reason why we have them, is for equalizing, right? It's to make it so that if you commit the same crime in Miami that someone commits in Alaska, then it doesn't matter that you're in different states, and it doesn't matter that you have different judges, and it doesn't matter that you have maybe different sentencing cultures, that you're getting the same sentence in both places. But something I've written a little bit about is just the way the Supreme Court has interpreted ACCA, is specifically with the categorical rule, with getting rid of the residual clause, and then in Taylor, I think sort of exacerbates that in saying that attempt crimes are going to be viewed separately, differently. It really becomes a little bit of kind of a gotcha kind of thing about whether your particular criminal history is going to make you subject to ACCA. And so it really undermines, I think, at least what I think is one of the purposes of mandatory minimums, of this idea of equality and making sure that people get the same sentence if they do the same kind of thing. I don't know why, for example, it's hard to explain. I mean, I'm sure, folks in your line of work have to explain this, but it seems very difficult to explain to someone, for example, that they would have been better off, not shooting that guy during the attempted burglary and just going ahead and completing the burglary, right? I'm sorry, I guess it would have been flipped. That they would have been better off shooting the guy.
Right, better off shooting him.
Yeah, it'd just be better off shooting him than getting convicted of attempted burglary than actually just running out with the stuff that they stole, right? And then being convicted of burglary. That those two crimes, one of them, the more violent crime, is not going to give them an enhanced sentence, but the less violent crime is. I just find that just very difficult to stomach.
So from technology in the Fourth Amendment to Armed Career Criminal Act, those are controversial, but more controversial is clerkship hiring. Your colleague Newsom hires them when they're in like sixth grade.
Right. Yeah.
It's become earlier and earlier. What should we be doing with clerks? When do you hire, and how should we be dealing with this issue? Because it's become a big problem.
It has become a problem. It's a collective action problem, right? Because nobody benefits, I think, from the system that we have right now, which is really kind of the Wild West. I'll just give you an anecdote. When I first joined the circuit, I got a flood of clerkship applications, right? I hired up through kind of 1 or 2 years out, and I was like, that's all I'm going to hire. And so I would get these applications that would trickle in from people, and I would tell them, look, you're applying for 3 years from now. Like, I'm just not hiring for 3 years from now. Come back when it's closer to time. Literally none of them would come back when it's closer to time, because the week after I told them that I wasn't hiring, they would just get hired by somebody else.
Right.
So there was no benefit to either the applicant or to me to say, like, I'm not going to hire you right now. So that's the collective action problem that we're having to deal with is, as long as everyone isn't agreeing to wait, then there's no reason for anybody to.
So what do we do?
Yeah, I don't know. I mean, I internally have some kind of things that I do to try to make sure that the kids who are applying to me know what they're getting into and are sort of ready to apply for a clerkship. I would really, I guess here's the thing. Right now, doctors have a medical match system, right, that connects them, where it's basically, I mean, it's one of the most efficient systems that you can get to go from medical school, to an internship fellowship. It's sad. Lawyers, we're supposed to be trained in creating systems, and we have this sort of wild, wild west about how to do it. So I would like something more like a medical match system, something less where it's just a delay on the time and everybody waits to a particular time, but something more like, if you bid Brasher as number one, then that would be flagged to me in some way, and that we could connect in a way that's sort of optimal for everybody, instead of doing this kind of like race to the bottom that we currently have now.
So how far out are you hiring now? Like if I wanted to apply now, when would I be applying for?
I am hiring 2 years out right now.
Uh-huh.
So yeah, so I'm not, I am getting applications for people for 3 years out, but I'm not hiring 3 years out. I'm hiring 2 years out.
And what are you looking for in a clerk? Like, how do you decide?
Yeah. So the first cut that I do is just whether this person can be helpful or not. Right. I mean, I will say, I think it goes back to the point I made about district judging and court of appeals judging being very different. I mean, court of appeals judging involves research and writing, and that's basically all it is. And so that's all my law clerks do is research and writing. And there are some people that are going to be excellent lawyers, that are not going to be maybe they're capable, but just not going to be happy spending a year locked in an office research and writing. Right. So that's the first kind of cut I do is, are you going to be able to help by research and writing? And are you going to go insane during that year if that's all you get to do? Once again, very different, I think, than hiring for like a law firm or an associate position, something like that. So that's the first cut I do. And then, so that's just sort of like, are you qualified? And then once you get to the people that are qualified, I look for folks that I think I'm going to get along with well. I look for folks that I think, once I start hiring for a particular year, I kind of look for people who I think are going to get along well with the people that I've already hired. And then, sort of just like I say, like, are they going to be fun to hang out with for a year?
Yeah. Yeah. Because I mean, you obviously get really close with your clerks. I heard you talk about having lunch with your clerks and how, you've carried on that tradition that Judge Pryor used to do with having lunch. But Pryor would always go to the same 2 restaurants, right? Like every day.
Yeah. So he goes, I think there are 3 restaurants on his rotation right now. Yeah. And so, so what we do, I'm very, I think a lot about how to like train my clerks and about how to teach them, basically my theories about things. And so what I do is we do 2 lunches a week that are mandatory for them to attend. One is we go out to a different restaurant every Monday. And it has to be a different restaurant. There are only a few times when we repeated. So that's good. It also forces them to kind of like look at places in Birmingham and kind of like figure out where they can go and kind of get out into the city a little bit more. So we do that every Monday. And then every Friday, we do what I call a substantive lunch, which at the beginning of the year is me like spending an hour telling them what I think about something. And we do that it's just like a brown bag that we do in the office. And then as the year goes by, those lunches usually turn into an hour discussing some legal issue that's come up in a case, right? So, if I've got some opinion that I'm kind of working on and the clerk who's drafting the opinion and I are going back and forth about how it should be written, I may we'll talk about this on the Friday lunch, right? And we'll kind of brainstorm session with all the other clerks about that. So those are the two things that we do.
What an unbelievable Friday experience for them that must be. I'll say this, for me, clerking was the greatest job I ever had. I clerked for a judge, Judge Edward Davis down here in Miami, who's before your time, who was just it's so great. And my first Friday with him, he would call his clerk son, and he'd say, "Son, go into my office and pour 3 glasses of the whiskey that you find there for your co-clerk and me." And on Friday afternoon, that's what we would do. We would have a whiskey with the judge and talk about the week. And my hand was shaking when I was pouring that whiskey the first time, but it was like the greatest Friday afternoon tradition, just to sit with him and talk about the week. And I'll never forget those Friday afternoons.
That's funny. Well, that raises. So when I was a district court judge for the brief time, I set a Friday meeting with there was no alcohol involved, but I set a Friday meeting to do the same thing. And we would walk through the week and what had happened and where everybody's cases were. And, we'd talk about the news and stuff like that too. And then I started doing that on the Court of Appeals. And the answer was, well, the cases are in the same place they were last week, right? Nothing on any of the cases, right? Nothing. So I had to think of something else to talk about, which is why I ended up with this kind of substantive lunch idea.
I love it. And so, you've been great with your time. I like to end these interviews with judges about, what you do other than the law. What hobbies do you have? What do you like to do when you're not writing opinions and thinking about the law?
Yeah. So I have a couple of hobbies. The thing that honestly, the thing that I enjoy most, sort of a true just hobby thing that I enjoy most, is doing word games and crossword puzzles. I used to read a lot. I still read a lot, but you come home after reading literally all day. And some days when I'm preparing for oral argument, I start reading at 8:00 in the morning and I don't stop reading until 7:00 at night. And it's just, you can't come home and, crack open a mystery novel or something after you've done that, but you can do a crossword puzzle. So I do always do the Wall Street Journal Friday crossword puzzle, which is also a meta crossword puzzle. You don't do crossword puzzles, I assume, by the way you're looking at me.
I have, but what's a meta crossword puzzle?
A meta crossword is where you figure out the crossword, you solve the crossword, and then there's a puzzle within the puzzle. And so the Wall Street Journal has the best one of these. It comes out on Friday. You can work on it through the weekend, and then on Monday, they give you the answer to the meta. So it's kind of a complicated thing. But
how often do you solve it?
I have streaks. There was a while there where I solved it for 4 months in a row, and it was amazing. And I was like, what are they doing? They're making these too easy. But I will say it's been a couple of weeks now since I've solved it. I'm feeling like I'm not doing very well.
And do the clerks do it now too, or no?
No, yeah, I had a clerk last year who did it with me.
Come on, they got to do it.
Look, it'd be cruel and unusual punishment to make them do the same thing that I do.
Well, that's a good place to end, Judge. Thank you so much for doing this. It's been a lot of fun and really appreciate you taking the time.
No, it's been great. You have a great podcast. I appreciate you doing it.
I really enjoyed having Andrew Brasher on the show and want to thank him for spending his time with us and discussing all these great topics. Next week, we'll get back to criminal defense lawyers and we'll have one on talking about a high-profile case. But I've been enjoying talking to judges and what makes them tick, and I think it's really interesting to dive into that. In any event, thank you, Judge Brasher, for doing the show. We'll be back in 2 weeks on For the Defense. My name is David Oscar Markus. Thank you for listening.